Justice to the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court will draw near to their attendance and they shall be heard.
Have a seat, everyone. Okay, I have down case number 480.1 as being submitted. Is that right?
Accurate.
Okay.
I'm Matt.
Okay, well, I'm going to call you up here in a second, Matt Lemke. Okay, so case number 416, Leslie Schlitt versus Deborah Campanella. Why don't you come on up? Counselor, whenever you're ready.
Good morning, Your Honors, and may it please the court, Daniel Strollo for appellant Deborah Campanella. Voters should not be denied a meaningful choice as to their candidate in a primary simply because 3 redundant words were omitted from a designating petition. The petitions that were the subject of the challenge in the lower court are clear in what they mean. The statement of the witness clearly conveys to its reader what the witness observed and what the witness is attesting to. The omission of 3 words at the end of that paragraph from the model language of the statute does not invalidate the petitions, and that is a conclusion that is consistent with the savings clause.
Counselor, we have a dangling sentence here, don't we?
We do.
And so someone who reads that statement has to fill in the blank.
They don't need to fill in the blank because the preceding language where the witness attests that the individuals subscribed their names to the sheet before them. The only missing language is that the same person that stood in front of that witness and committed that act then would orally verify that they committed that act. It's entirely redundant.
Again, though, it's dang, we don't know. You have to make it up in your head, whatever that the rest of that sentence says.
If you were so inclined, yes. And obviously neither a court nor the Board of Elections would be forced to make things up. But in this instance, they don't have to. There's enough there for them to know that there's been substantial compliance with Election Law 132. And that's the savings clause that's contained in section 6134. As long
Is that the standard, substantial compliance?
Yes.
So we have to look at strict compliance.
no, substantial compliance is the standard here, and that's both statutory and from a long line of cases coming from the Court of Appeals that are cited in both my brief as well as the Board of Elections brief in this instance.
So Justice Doyle did say that it needed to be strict compliance.
He didn't.
Why is he incorrect?
Because it runs contrary to the statute in that instance. The language, substantial compliance is even within Election Law 6134. That's the standard that has to be applied here. And that's consistent with the legislative recognition that this process, this petitioning process, is not something that lends itself to perfection. So we look to substance over the form that these documents take for the purposes of enfranchising voters. That's the entire purpose of election laws, to give people a choice and to prevent fraud. There's no claim of fraud. There's no suspicion of fraud. It wasn't even.
If I could frame this, the issue here is the witness statement, and the witness statement is the equivalent of an affidavit.
Correct.
And the witness is saying, so under the statutory framework, 2 things. The voter signed in my presence and also identified themselves to me. And that's the part where you're asking us to imply that from this open-ended sentence, where in assuming that the designating petition ends after the word individual, how can we read that as the witness affirming that the voter identified themselves?
Because the verbiage refers to to one person, the individual. So the natural conclusion that's drawn from that, and I would say the only conclusion that possibly can be drawn from that, is this person is the individual that they say that they are. It doesn't say, for example, the individual upon whom this person acted subscribe their name to this instrument, as we so often see in a jurat clause.
So
It doesn't have.
there's no other interpretation of that dangling phrase here.
There's no other reasonable interpretation that's consistent with the purpose of election law to enfranchise voters and prevent fraud. Yes. I would also like to address, if I may briefly, one issue that was raised in the respondent's brief, namely this idea that both my client and the Board of Elections defaulted here. That's clearly not the case. Procedurally, they are stopped from making that argument because upon receiving an unverified memorandum of law as reply papers, as directed by Supreme Court, I would add, they never filed a notice of rejection. If they wanted to be heard to complain that it was unverified, they would have immediately needed to file a notice of rejection rather than a motion. The court below also didn't hear the motion. It just decided this and then denied the motion as moot. I would finally add, as to the default issue, that a defaulting defendant only admits traversable allegations in commencement documents, and the entitlement to legal relief, particularly of a drastic nature like this, is not a traversable allegation. It's a legal conclusion that the court needs to make. There's no factual dispute here, so there couldn't possibly be a default.
Thank you, Counselor.
Thank you.
Morning, Your Honors. Maria Rodi from the Monroe County Attorney's Office for Respondent Appellants, Monroe County Board of Elections and their respective commissioners. Your Honors, if I'd be happy to answer any questions.
Why don't we take the issues in reverse order? Why don't you talk about the issue of a default or of your standing, the lack of the answer, et cetera, the last procedural issue that was
Yes,
brought up?
sir. As far as the default, I reiterate the points that Mr. Stroll made about there being no rejection made. Also, as was set forth in the Board of Elections papers below, the court, the way that procedurally the process went is that when respondent said that the answer should have been submitted, it actually would have been legally 2 days before we even had the hearing. These election matters happen very quickly, can be very informally. The parties all appeared before the judge. The parties all agreed on the record that there were actually no factual issues, that there were just legal issues, and the parties were directed specifically by the judge to submit responses on that legal issue only. So I would say that the default is not an issue here.
Okay. You can continue if you have anything to add to the argument we have already heard.
I don't, Your Honor. I think Mr. Stroll made the case very well. I'm happy to answer any more questions, but otherwise I'd respectfully rest on our brief.
We thank you.
Thank you.
May it please the court, my name is Matt Lemke on behalf of the petitioner respondent Leslie Schild. I want to get right to the heart of this thing, and that is where the statute says this should be, this is the content of the witness statement. We are in a situation where the statute is prescribing language that is required. Strict compliance is required where the statute is specifically stated. You can't just leave out words of the statute and expect that people are going to.
Well, doesn't the statute say that you have to substantially comply with the form?
It has to substantially comply with the form, and by that, our interpretation is that means the kind of the formatting, okay, as opposed to the specific language of what should be in the subscribing witnesses
You mean
statement.
your position is substantially as follows means formatting, like font size and
Order, for instance, as we put set forth in our papers below and in our brief, the fact that fill in the name comes before the line or fill in the date comes after the line, those types of things. But for example, I mean, if we look at just the paragraph here, that every word is important. For example, if we were to eliminate in this paragraph each of the individuals.
right, that's hypothetical. That's not what we're dealing with here.
Right.
We're missing 3 words.
Correct.
And their position is that the only individual referenced anywhere in the statement of witness is the voter. And there's no other way to read that, their statement, other than that the individual referenced there is the voter who appeared before the witness and signed the petition.
Right.
Do you agree with that?
No, I don't agree with that. That's
Is
not
there
the,
some, is there some other ambiguity because those words are left off?
perhaps, and the answer is yes. And to that issue, I would point the court to page 57 of the record. I want to direct your attention to page 57 of the record. In page 57 of the record, there is a statement of a witness named Christopher Vossler. And in that statement, he says that each of the individuals whose names subscribe to this petition containing 14 signatures subscribed the same in my presence and indicated and identified himself or herself to be the individual who. And if you look at two of those signatures 9 and 10, they're clearly identical, written by the same person, filled in the address, 65 Parnell Drive on both of them, written by the same person, town of Riga, in the exact same handwriting. If you look at that, if the end of that sentence says who has authority to sign for an individual listed, you're golden. You have complied with the statement of witnesses and the affidavit is true. That is not what the law requires. Not to put too fine a point on it, if we go to the prior page 56, the same two people on April 1st, after March 17th, at 65 Parnell Drive, signed that petition too. So the question becomes whether or not Christopher Vossler, who I read all these petitions, was the witness on one petition. The question becomes, is a person unfamiliar with the law like us, have not parsed the statute, do they have enough information in that petition underneath their statement of witness to know exactly what it is that they have to be able to affirm under oath that the statements that they are making is true? So I've just pointed out a perfect example that is not just, this is not just theoretical. This is an actual example in the record of a statement where if the dangling sentence ends, has authority to sign for their husband or wife, housemate, roommate, partner, then that petition is good. And that's not what the law requires. The law requires that the person who signs it is the person whose name appears there and that they're the one that signed it, not someone signed it on their behalf.
So it's your argument that the phrase that's missing is important, an important descriptor and something that's required by the statute.
If it were not, yes, Your Honor. And if it were not, then we would have to conclude that that language is superfluous. Could have just left it out. And of course, we know that by the principles of statutory construction, we don't deem language in a statute by the legislature to be superfluous lightly. They could have just left it out of it. And they didn't do that. They included it in the language, and therefore it must be in the statement of witnesses, and it matters. And it matters. It's not a connector or some other word that we could have wordsmithed differently. These are material words that are important to the statement itself and the affidavit.
Okay, thank you very much.
Okay, thank you.
Morning. No, we're on the case 415. Onondaga County versus State of New York. Case 415.
That's the characters.
We have 8 lawyers. One is remote. Counsel, Biden, can you hear us?
You
You
can't.
have to unmute yourself for a moment. Counsel? We can't hear you. We can see you, but we can't hear you. Didn't want to start without making sure that you can hear what's going on here. You go last, but you can hear us. All right, we'll figure out your audio later. As long as you can hear us, we will proceed. Ms. Rosenbluth for the state.
Good morning, Your Honors. May it please the court, Sarah Rosenbluth for Governor Hochul in the state of New York. The even-year election law is a valid general law and a proper exercise of the legislature's plenary lawmaking authority, including its plenary power over the whole subject of elections. And the alternative, though, it is a valid special law because it serves the state's substantial interest in maximizing voter participation. First, the even-year election law is a general law because, with certain exceptions that are constitutionally or practically required, it applies uniformly to all elected county and town offices across the state.
Counsel, before you get to the Article 9, Section 2 general election, could you address the county's Article 9, Section 1 claim?
Yes. I think these arguments are related. So if I could explain why it's a general law and then explain why Section 1 doesn't trump that, if that's okay. Which is so just to start from the general law proposition, because it applies to all it's a general law because it applies to all legislative bodies of all counties and towns, which are constitutionally required to be elected. And it applies to all county and town executive officers, except insofar as a locality.
I'm sorry, I want to go back to Justice Lindsay's question.
Okay.
If it's a general, if the counties are right here and they have rights under Section 1 of Article 9, it doesn't matter if it's a general or a special law.
Well, okay, so let me.
That's where we start, right?
So I don't think that's where you start. I think you start with whether it's a general law, and that's because the word general law appears in Section 1H, and counties only have rights under Section 1H1 to the extent that they are quote unquote empowered by general law.
Well,
So
their argument really, as I understand it, which I don't think you've addressed at length, if at all, is that the state's power under Article 9, Section 2 is subject to the Bill of Rights, the local government's Bill of Rights under Article 9, Section 1. It's right there in B. So they're saying the state, Article 9, Section 2 gives the state authority to act by general law or special law for all these different, but they're saying it's provided they don't have a right set forth in Section 1. So that's what we're getting at.
Yes, I understand. And I have two responses to that. And I do think our reply brief addresses this. So the first response is that, yes, it is subject to Section 1, or that's their argument. But even on that argument, if you go back to Section 1H1, it says they shall be empowered by general law. So the right given in Section 1 does not purport to trump Section 2. It's still dependent on the legislature enacting, implementing legislation, which is what has happened here. And the second point, Your Honor, is that I would direct your attention to the matter of Radich case, which said that, and so that was a case by, there's a Fourth Department decision that was affirmed by the Court of Appeals. And in the Court of Appeals decision, it said that because it's a general law, the law at issue there was a general law, and that was a law directing the appointment of certain local officers. Because it was a general law, it said Article 9 is not implicated here. So I think that case really controls the analysis here because it is a general law.
Would you agree with this much? If the counties have a constitutional right to set terms of office for public officers, if they do, then this law, this even year law, is unconstitutional.
Well,
If the counties have the constitutional right, not statutory, but constitutional right under Article 9, Section 1 to set the terms of office, then this law falls. Would you agree with that?
If that's, I dispute the premise,
I
but if the
understand.
premise is true,
Right? The premise is true. This law, even though it doesn't deal with terms of office, it restricts the county's abilities to set terms of office.
but so I think their theory is that any purported right to set the terms of office is located in Section 1H1, which is explicitly made subordinate to general law. So I think that argument has to fail. I do want to just note here that obviously there are various statutory exemptions to the even year law, but those statutory exemptions account either for pre-existing constitutional constraints or the existence of local discretion in structuring local governments. So it won't apply to a county executive office if that county has already made a choice in the exercise of its discretion to essentially take the office outside the scope of any such even year law. So the exemptions are not intentionally targeting a given class of localities for differential treatment. The law is not reverse engineering a universe of localities in order to reach a desired outcome.
So your answer, if I could just paraphrase, just so we can understand, because we got a lot to get through here
Sure.
before we move on to the Section 2 argument,
Yes.
is that if Article 9, Section 1 granted counties the right to set terms of their offices for their public officers, this law would fail. However, in your view, Article 9, Section 1 does not give the counties the right to set terms of office. And that alternative, it does give the counties the right to set up alternative forms of county government, but that does not include terms of office. That's your argument on Section 1.
Not quite. My point is that it does give them a right to adopt alternative forms of government, which we can assume for the sake of argument also includes the right to set terms of office. But that right is not a freestanding absolute constitutional right. Is it a right? It is a right that depends on implementing legislation by the legislature. And that's exactly what the EYEL
And I think that's part of this is where I'm trying to get my head around.
Yeah.
Part of the argument here is that the enabling legislation, municipal home rule law, implicitly recognized in Article 9, Section 1. This is the argument.
Mhm.
The right to set in setting up the charter and establishing offices, the right to set the term of office. The right to set an office implicitly includes the right to set the term.
That's the argument
That's
you're
the
on.
argument here, and
But the
I think your point is that's an unenumerated right in Section 1. Section 1 doesn't grant that right to set the term of office.
It doesn't grant a freestanding absolute right. There's other rights in Section 1 and A, B, C, D, E, F, for example, that don't depend on enabling
But if
legislation.
that right were in Section 1, it could not be diminished by virtue of a general or special law
Sorry, do you mean if it were in Section 1 outside of 1H?
outside of 1H, which is where
Right, but it's not. It's not.
it's an unenumerated right.
It's I think, it's not, first of all, I just want to specify that it's not clear that this law does implicate the right to form an alternative form of government. We are sort of proceeding on the premise that it does, that we can assume for the sake of argument that right subsumes the right to set the term of office. But again, that's not a freestanding right. It's a right, they have that right only insofar as it is granted by the legislature. And what the legislature grants, the legislature can subsequently modify or amend. And that's exactly what has happened here, because the legislature, in passing the EYEL, has amended Municipal Home Rule Law, Section 34.
Is that a right they had up until the adoption of this law? Because, the argument is for near 100 years, we've been setting the terms of office.
No, their rights have always been dependent on the rights that have been granted by the Municipal Home Rule Law. So Article 4, Section Part 1 of the Municipal Home Rule Law is known as the County Charter Law,
Right.
and that is the implementing legislation. So all of the county's rights in this regard are drawn from the MHRL.
That I think is your argument in response to our questioning here, right? Is that there is no constitutional right. The right to establish those offices, which includes the term of the office, is exclusively within the province of the Municipal Home Rule Law.
Yes, I think you
And
could
it's
phrase
subject to
it.
amendment by general law or
Yes.
special law.
Yes, I think that we could phrase it that way. And section 1H1, essentially on that reading is a directive to the legislature to enact laws carrying out the purpose of section 1H1, but it doesn't purport to grant independent rights, enforceable rights to the counties absent legislative implementation.
Right. They seem to give particular strength to the fact that the terms of office is in their charters. These counties all have charters that was authorized by the state, by the Constitution. And they seem to think that can withstand state law more so than just a regular local law. Do you see any distinction between a law and a charter and a non-charter law?
Yes, I mean, it is true that as a general matter, county charters can be inconsistent with state law in a way that local legislation can't. However, it's subject to a very important carve-out, which is articulated in section 34 of the MHRL, which lists enumerated categories of topics of state law that do supersede contrary charter provisions. So one of the amendments that the legislature made in enacting the EYEL was adding a new category to MHRL 34.3 and 3H. So as a result of that addition, it's clear that the county, it's really crystal clear in the statute that the county law or county charter may not supersede state law regarding the timing of elections and even versus odd years. And there's nothing prohibiting the legislature from adding new categories to that list. If I could just move on briefly to the special law issue, if that would be of interest.
We interrupted you, at least I did. You're
Yeah.
talking about the general law. Their argument is not, general law we know is defined as applying to all the 57 counties outside New York City. They argue this is not a general law because there's certain counties that have their executives don't run for office.
Right.
They are not elected.
Right.
And there's one county, I guess Putnam might have 3-year terms for their county legend. This doesn't apply. So that seems to be their response to your general law argument.
Right.
What do you say to that?
So I started to touch on this earlier. I have two responses. One is that the law absolutely does apply to all counties because all counties and towns are required to have elected legislative bodies. So the law does apply to all county and town legislative bodies equally across the state. It also applies equally to county executive officers. With the only exceptions are to account for pre-existing constitutional limitations that, of course, the legislature could not override by a simple statute, or to account for existing local discretion in how it decides to structure the county executive position. So, of course, a law targeting the timing of elections by definition could not apply to an appointed office. It just would make no sense. That's a square peg in a round hole. So the class here is rationally defined.
So it applies to all counties, but not all officials of county, not all county officials.
It applies to all county officials
Have to run for office.
who have to run for office to the extent that their terms are not set by the Constitution and to the extent that and the 3-year limitation is just sort of gets around, is to do with the fact that as a matter of math, if you run for a 3-year term, you're going to be up either in an even year or an odd year, and it goes back and forth. So instead of mandating that the term of office change, which I think would be a greater intrusion on home rule powers, the legislature just carved that out of the statute.
Last point in general law, then we'll let you get to the special, is the judge below relied on NIDIC, a
Yes.
miscellaneous case that was affirmed by the second part without any reason, went up to Court of Appeals.
Yes.
And trial judge said that settles it.
Right.
It's not a general law.
Yeah.
Your response to NIDIC?
So NIDIC is, I think, pretty easily distinguishable, and here's why. The law in NIDIC granted it was part of the county law section 400, but a different subsection. And that subsection said that the governor has the authority to fill vacancies that arise in, I forget, it was either appointed or elective offices. And so it only granted the governor authority to fill vacancies in certain types of offices. Here, the subject of the statute is elections. So of course it could only apply to elections. So I think that's a really critical difference in thinking about how those two different statutes operated. So we do believe that, of course, even if this court disagrees that it's a general law, it should still reverse because the even year election law is a valid special law that serves a matter of substantial state interest. It's true, of course, that the election of local officers is indeed a matter of local concern, but that does not end the analysis. Rather, as the Court of Appeals has explained most recently in the Empire State case, there's a sizable area of overlap in which the state legislature acting by special law and local governments have concurrent powers. And this court has already expressly held that the state does have a substantial interest in the method of electing local officers or method of filling vacancies in local offices. In matter of Radich, as I mentioned, which was affirmed by the Court of Appeals, this court explained, quote, "It's not unreasonable that the state should be concerned with the orderly succession of local government executives who must act responsibly in accordance with state as well as local law, and who inevitably must deal with matters of state concern and with state officials." So we think that Radich controls here, but more fundamentally, the state also has a strong interest in fostering robust democratic norms and values, ensuring the representativeness of all bodies of government, and in maximizing public participation in all facets of civic life. Unless there are any questions on that, I'll briefly turn to the Anderson-Burdick section.
On the special law
Yeah.
issue, the substantial state interest is increasing voting for county, town, village offices.
Yes,
That's the justification, not cost savings, right?
we're relying on the voter participation.
And
rationale.
city elections, of course, don't apply here.
Correct,
Those are in odd years.
correct,
Matter of fact, there's a constitutional provision that says city elections have to be in odd years.
correct.
The purpose of that, are you aware of the purpose of that constitutional amendment to require the cities to be in odd years? Why the legislature and why
I'm not aware of the history of that amendment, Your Honor.
according to the Court of Appeals, the reason for that amendment for having city elections off years is to remove them from state and federal elections. It's too cluttered, too confusing. So we have a finding in the Constitution that says we want our city elections away from all that noise.
Sure.
And now this seems to be a contrary intent and purpose for county elections. We want to have them join all those other races. So we have one constitutional purpose, let's have city elections removed from state and federal, and then the legislature here says we want to treat town elections differently. We want to have them included. Is there some inconsistency there?
I don't think so, because it is the legislature's intention to eventually propose a constitutional amendment that would change the city elections as well. And that was made clear throughout the debate here. Obviously, that is enshrined in the Constitution, so that cannot be changed by simple legislative act. It's true, of course, that this is a bit of a piecemeal approach, and it necessarily is due to the kind of comprehensive nature of the New York State Constitution that really articulates a lot of different things. So the fact that the legislature is proceeding sort of step by step, as it must, I don't think detracts from the state interest here. I will move on to the last section unless there are further questions. Okay, so I just wanted to briefly address the individual state and federal constitutional claims that are subject to the Anderson-Burdick test that has been outlined by the United States Supreme Court and adopted by the Court of Appeals, and this court, I think most recently in the matter of Kowal case, that was 2 years ago. So those claims fail as a matter of law. For an individual constitutional claim against an election law to survive a motion to dismiss, it generally must allege that the law either singles out a particular group of voters, parties, or candidates for differential treatment, or that it imposes a burden that risks outright voter disenfranchisement. Plaintiffs here allege neither. The even year election law simply changes the timing of an election in a uniform manner on a prospective basis and applies equally to all voters, parties, and candidates. It therefore imposes at most only reasonable non-discriminatory burdens on constitutional rights, which are justified by the state's important interests. And I just wanted to highlight some language from the Kowal case that I think sheds light on how to analyze these claims. In the Coal case, the court talked about and that was a case that was decided on the pleadings, I should add, and I litigated that case, so I'm very familiar with it. But the court talked about how we have to examine the alleged burdens in a realistic light, and to the extent that in a realistic light, and the overriding standard is adequate ballot access. And I'll just make the point here that of course, we are at the pleading stage here, but most of the alleged burdens involve sort of speculation about things that might occur in the future rather than events that have taken place already. And one of the chief sort of worries that petitioners put forward is the worry of increased lines and waiting time to vote. I acknowledge that that's a factual issue, but I think that in light of the fact that that's just a hypothetical, and also in light of the fact that Coal says we can look at this in a realistic light, one of the things we can consider is that we now have universal mail-in voting in New York. So
We have 9 days of voting as well here.
and early voting.
That's your point, long lines, right? You want people out voting.
Well, I mean,
Yeah, that's your point. That's a good problem to have. We'll find a way to get.
stating it, yes. I mean, certainly the longer lines is a function of more people voting. We think that there's like, the State Board of Elections has adequate infrastructure to, they're very.
They can deal with voters.
Yeah, that's what they're there for. So I think that, and to the extent that there is a worry about, oh, this ballot is so long, I really need to study it. You can request a mail ballot and you can complete it over 2 months, 6 weeks, maybe. I think that's all I have.
I just have one comment,
Yes.
Roland. I know you're not advancing this point, but by syncing these elections, not only that you increase voter participation, wouldn't it be saving the taxpayers hundreds of thousands of dollars?
I mean, yes. I mean, we haven't advanced that as our overriding justification because obviously there are still local elections that will be taking place, and we haven't succeeded yet in entirely consolidating local elections with state elections. But yes, it does result in a savings to taxpayers. It doesn't totally eliminate that, but it absolutely does result in taxpayer savings.
Well, I asked you about that earlier and I thought you said no, you weren't relying on it.
We're not relying on it, but to the extent it's I'm being asked about it, I think that's true. I don't think that's our primary justification right now. The reason why we're not primarily relying on it is because obviously there is still a cost to taxpayers because there are still local elections.
So how does it save money? People still have to go to the polls. There's all these offices that are exempt. You got to pay the poll workers.
It's a one step towards saving money, and that's really why I'm not intending to.
Right. But the main goal, the main primary purpose, as I understand it, is to get more people to vote for county, town, and village elections. People who wouldn't vote in an off year. Who have no interest in voting, the goal is to get them to the poll with some headliner. We're gonna have a headliner like the presidential race or the governor, and we're gonna draw people in who otherwise would just sit home because they don't really care that much, but we want them to vote.
It's to leverage the fact that participation is already way higher in state and presidential years. So if we leverage that, then we can.
Participation from people who really wouldn't care to vote otherwise.
Perhaps,
Okay.
yes. Yeah.
All right, I think we understand.
Thank you very much.
Thank you.
May it please the court, Brad Hunt from McKinsey Hughes on behalf of Dustin Sarning, who's one of the commissioners of the Onondaga County Board of Elections. I'd like to focus first on the Section 1 issue. And what I'd like to do to start with that is to focus the court's attention on two very particular phrases from the text of Section 1, which I think are very important. First of all, what Section 1H1, this is the core of their Section 1 argument, what it actually says is the words, counties shall be empowered by general law to adopt alternative forms of government. Counties shall be empowered by general law. It does not say counties have the right under this Constitution to adopt alternative forms of government. It says they'll be empowered by general law, and they are empowered by general law. That is the municipal home rule law. So the state complied with Section 1 by empowering counties to adopt alternative forms of government when the state adopted the municipal home rule provisions in 1963. That's not disputed. And really, Section 1 says hardly anything else about the circumstances in which hardly anything at all about the circumstances in which a state general law can override a county charter. The one thing it does say that sort of gets at that issue is something that's not mentioned, as far as I know, in the plaintiff's briefs, and that is in section 1H2. Section 1H2 actually says that after the adoption of an alternative form of government, such as a charter, and I quote here, any amendment thereof by act of the legislature then shall be subject to permissive referendum if certain things apply, which unquestionably are not at issue here. So 1H2 specifically expressly contemplates that charters can be amended by act of the legislature. And then to determine the circumstances in which a state general law can actually, supersede a charter, there's nothing else in section 1 to look at. There are two laws that you look at. One is the municipal home rule law itself, which is a statute, not the Constitution, but it's what implements, it's what empowers counties to adopt charters.
I'm following your argument, but what I'm hearing the county say is that implicit in organizing ourselves and establishing a charter, you don't have much of a government if you don't set a term of office. That's so basic. And that's either, and if it's not expressly enumerated in H1, it's there by implication.
I don't think it's there by implication. I think section 1.
How can you establish a charter under any circumstance? This is their point, I think. How can you establish a charter, and that they've been doing this for nearly 100 years, and setting up forms of local government without having had the power, the absolute power to set the terms of office?
You can set it up, and no one is arguing here that the Onondaga County Charter was invalid when it was enacted in 1961. You can set it up, but it's subject to being superseded by state statute if the state statute is consistent with the municipal home rule law and with section 2 of Article 9, which in this case are.
Section 2 you just read, there has to be a referendum, does it? They're not?
There does not, and they haven't even made that argument. None of the conditions in section 2 apply.
The provision you just read talks about a referendum that the legislature, as provided by the legislature.
You're talking about section 1H2 of Article 9. Yes, and they have not invoked that provision, and none of the listed conditions in that provision are applicable here. So a permissive referendum only applies if one of those conditions is present. It's not here. So I think the clear implication is that a referendum is not required by section 1.
So if I understand your argument, then the power, the authority to set the term of office derived from the enabling legislation, not the Constitution.
Correct.
And you don't disagree that the new legislation would diminish the county's power to set the term of office.
It amends it. It trumps the charter. Insofar, on the specific issue that's legislated,
the question that was posed to your co-counsel earlier was, if we were to find a constitutional right for the local governments to set the term of office in Article 1, you would agree that
yeah, I know. I heard the question. I find it very difficult to answer that question as a hypothetical, because I think it depends.
But that's what the court below made the determination. The court below said that there's a constitutional right in Article 9, Section 1 for local governments to set the term of office. Correct?
Yes.
And that's what's in front of us here. And that's, I think, the thrust of the county's argument here. And if we did find that, you couldn't diminish that right by way of a statute. Do you agree?
I think I guess I would, maybe this is a way to answer the question. There's a right, which I believe is not pursuant directly to Section 1. I believe it's pursuant to the municipal home rule law, which is authorized by Section 1. There's a right to enact a charter and to provide for elections in terms of office in the charter. And again, Onondaga County did that. No one's arguing that the charter was invalid when enacted. There is not a right to set the terms of office in a way that can never be amended by a general law.
Yeah, we get that argument, and you may well be right. But what we're just trying to narrow the dispute here. And you don't seem to want to concede that if the counties have a constitutional right under Article 9, Section 1 to set the terms of office, if they do, this law must fall. You don't seem to want to make that obvious concession. Now, again, you can argue that it's not in there, the right to set terms is not in there, but if it is, and that's what the whole issue here is, one of the primary issues, not the whole issue, but the judge below found that there was a constitutional right to set terms of office. He didn't cite where in the Constitution it came from. They're saying Article 9, Section 1. If it's there, well, it necessarily follows that this law, the election year law, or even year, that restricts the county's abilities to set the terms of office, because we know every term this year's got to be 1 year, or most of them. And then thereafter, the county can't go with 3, can't go with 5, can't go with 7. So it does restrict. They have to go 2 or 4, right?
That's right.
So,
Yes.
okay. So it all comes down to, does that right exist to set terms of office in Article?
Yeah,
9,
I guess
Section 1?
sorry, I'm not trying to be difficult. I just
Yeah.
want to be careful here. I guess I would say the question is, does that right exist?
Right.
You know, would it exist in a form that cannot be superseded by general?
Right,
state
as
statute?
Justice Conte said, your view, it's a statutory right. The legislature can give it, they can take away. You
Right.
can't take away from the Constitution. There's a law that says the counties have that right, and here the legislature took it away.
Right, and that's their argument.
Well,
And
that's your argument, that it's a statutory right that can be yanked.
correct.
Yeah.
Correct. Yes, it's a statutory right, and it is it's governed by the municipal home rule law. And if you look, look at Section 34, it very specifically says that the legislature hereby imposes the following limitations on the power of counties to prepare, adopt, and amend county charters. That's Section 34(1) of the municipal home rule law. And then Section 34(3) says that except in accordance with the provisions of this chapter or other laws enacted by the legislature, a county charter shall not supersede any general or special law enacted by the legislature, which, and there's a long list of the kinds of laws that a county charter can't supersede, one of which is now the provision of the even year election law that's is codified in Section 34(3)(h). And another, frankly, which I also believe applies, is 34(3)(g), which refers to laws in the municipal home rule law itself. Basically the way the municipal home rule law is set up is it lists a number of general state laws that cannot be superseded by county charters. What's missing from that list are the New York County law and the general municipal law. That's what county charters can supersede. That's the whole idea of alternative forms of government, but they can't supersede many other enumerated general state laws.
Right, if you get by Section 1, then you're saying the issue becomes whether the state has authority under Section 2, Article 9, Section 2. That's
Correct.
whether it's a general law or a special law under certain conditions. You want to hit that briefly?
Sure. So I believe that this court's decision in Radich, which was affirmed by the Court of Appeals, is very clear and controls the general law issue.
What about Resnick? We get Radich on your side, Resnick on their side. The trial judge relied on Resnick.
I prefer Radich.
I figured you would.
I think that what this court said in Radich is an act is deemed general if it applies uniformly to a class, entry into which is governed by specified conditions. That's clearly the case here. The terms of the even year election law do not specify that they apply to certain counties, but not others. They apply to any elections for county positions except for certain positions that are enumerated, mostly because they have constitutionally specified terms. That's a class that's governed by specified conditions. And really, I think if you take the other view of what is a general law, it would be hard for anything to be a general law, because you've got a lot of counties in the state that do things differently in all sorts of contexts. So the exact way counties operate is always going to be different and is always going to change to some extent. The interplay between counties and statutes, and I think the Radich test, which the Court of Appeals affirmed, is the right one, and really makes sense here.
Before you sit down, council didn't address the savings clause in section
Oh.
3. Do you want to be heard
Yeah,
briefly about?
briefly on the savings clause, I mean, I think that the text of the clause really speaks for itself. What it says, this is section 3B of Article 9, is that existing provisions, quote, shall continue in force until repealed, amended, modified, or superseded. So it expressly contemplates that they can be superseded. So when the home rule provisions of Article 9 were adopted in 1958 and 1963, that didn't in itself invalidate any existing county charters at the time, but it certainly it expressly contemplates that they can be amended as long as the amendment is to proper, is pursuant to proper procedure under state law, which I think in this case is clearly the case under both section 2 of Article 9.
It wasn't much of a restraint on the state. It just basically said whatever the local governments have done so far, this amendment isn't going to nullify any of that. But tomorrow we can come back and nullify it.
Correct. Yeah, I think that's
a lot of protection there for the local government.
Yeah, but I think that's what it says, and I think that's correct. And I think they didn't want to tie the hands of the state, and that's consistent, I think, with the other provisions we've already discussed in Article 9 that do contemplate that alternative forms of government can be amended by general law.
All right,
Thank you.
Mr. Carney, good morning.
Good morning. May it please the court, Edward Carney for the Onondaga County plaintiff respondents, Oneida County, and Duchess is joining in my brief as well as my oral argument. So I think the court has a grasp of the issue. The real issue is what we say our rights come from section 1H1. And that section starts with counties. So we would say that counties have different rights than section 2. Section 2 starts with subject to the Bill of Rights. That has meaning. The Bill of Rights is section 1. And so we wouldn't say it's a statutory right, it's a constitutional right, because section 1H1 directs that the state legislature pass a law that implements the county's constitutional rights to have an alternative form of government.
Where's the right in section 1 to set the term of office?
Okay. So first, we would say implicitly, to your point, the structure of government includes the right to determine what type of offices you have, the terms of those offices, the manner of whether it's going to be elected or appointed. But let me give you just a little bit of history to answer that question, where I think I can answer where those rights come from. So, as the court is aware, in the 1960s, this was an amendment to the Constitution, and it added specifically this Article 9 1H1. What happened was to get a constitutional amendment passed, you have to go through 2 successive legislatures, and then it's got to go to the voters of the state of New York to ratify it. This took place in November of 1963. But before it was ratified by the voters, the state legislature passed the implementing legislation, Section 33. So who better than this legislature that 2 successive legislatures, who better than the state legislature to know what rights belong within 1H1 or what rights the county is entitled to? And when
I don't mean to interrupt you, but I will. So you're saying that the right to set the term of office is an unenumerated right.
I'm saying that
we can't. You're just,
is it in there?
Are you being clear with me that it's not in there? We can't find it. We're not going to read it.
Yeah, there's no debate.
It's not in there. So it's an unenumerated right,
right,
that arises by virtue of the interpretation of the enabling legislation.
That's correct. And my point is that this piece of legislation, the state legislation, Section 33, was passed before it went to the voters to ratify the constitutional amendment. So when the voters went to the polls in November of 1963, they knew exactly what this meant because the state legislature told them what it meant.
So are all the rights in municipal home rule law, are they exempt from being amended by this? Those are all constitutionalized in your view? All,
I would say the rights that the constitutional rights in this instance to form an alternative form of government, which, such as a charter form of government, I would say those can't be changed. So what happens here is
Let me press you a little bit on that.
Sure.
Okay, so if that's the case, and I think you're at municipal rule section 33(2), it provides for the establishment of a charter and the manner of elections.
Mhm.
Does that mean that the county has the right, say, if they want to set the term of office under that provision, to set a term of office of 99 years?
Well, there'd be potentially other constitutional limitations.
But if it's a constitutional right, what would be the limitation then? And if it's the term of office that the county has the right to set?
Well, it would depend on what, in other words, 99-year term. I guess that's an extreme case.
But it would be, in your interpretation, an appropriate exercise of constitutional powers to establish a 99-year term?
Well, let me say this. After this is passed, this constitutional right is passed, then at that point, it has to go to a double referendum. So in other words, your charter form of government is given to the people of the county that adopts that charter. And it has to pass within the city limits and outside the town, outside in the town. So if the term was set at 99 years, I guess they could reject that.
Who could reject it?
The county.
The county could reject it. I guess where I'm struggling is
The county voter.
I understand your argument. Right, the question that's in front of us is whether or not this statute is constitutional.
Mhm.
And it's not, and the question is not whether it's permitted, but whether it's prohibited. Whether or not the current statute is prohibited by the Constitution. And the state says it's not prohibited because we've always had the right to set the parameters for what the county can and cannot set forth in its charter. That's all we've done is amend the municipal home rule law.
And I say to that judge, that is a constitutional right and a directive that state legislature, that's how 1H reads, 1H1. It directs the state legislature to pass a law that implements the county's rights.
if we disagree with you on that, it doesn't mean you necessarily lose. Because the state, you have your backup argument under Article 9, Section 2, that the state can't intrude on this matter of local concern because it's not a state law and there's no substantive, with respect to special law, they didn't follow procedures and so forth and so on. You wanted to hear it on.
That's correct. So two points. One is that we don't believe this is a Section 2 case. Those are cases for local governments such as towns and villages and cities. And so we say our rights directly come from Section 1. But we talked about the Radich case. That's a Section 2 case. It's a case that deals with Article 13 of the Constitution, vacancies. And why I say that is it's a city charter. It's not a county charter. And so this is a question, to try to answer your question, Judge Lindley. Are you asking, to answer the question whether we meet out or whether they meet out the general law obligation?
Yeah, like assume that there's no constitutional right under Article 9, Section 1. And I know the counties believe there is, and it's an interesting issue. Let's say the panel were to go against you on that. You could still prevail here by attacking this law.
Not being a general law.
It's not a general law, and even if it's a special law, then
Yeah, so
it doesn't meet the criteria.
So when you break down the classifications, it doesn't apply to appointed positions, only elected. It doesn't apply to certain local offices that have state duties, district attorney, county court judges, etc. It doesn't, the most significant exception or carve out is it doesn't apply to folks that counties that have terms that are 3 years. And I think the reason that's carved out is because they know, the state legislature knew, to accomplish what they wanted to accomplish, they would have to change that term of office. They want this court to focus on the idea that it's the even year election law. That's what's in play. But it's the effects the even year election law has on the county's constitutional rights to set terms of office. They didn't touch that. And when they say there's a carve out with 34, an exception, that a charter has to be, consistent with the right to run with the even year election law, what's telling is they never amended section 33 to take out the terms of office. Okay, moving on. I just want to make that point to say, it's a good point. I'll give you that. Let me make one point. If the court were to disagree with us and reverse this, we would say that it's not applicable to this year's election. The election cycle started February 1st. The certificates are filed, county legislative races, whether there's a necessity to put the term of office in it or not, which we did, Onondaga County did, that started the process. People went to the nomination process. They decided, I want to run for office. Maybe they don't want to run for a 1-year office, but at the time that started, the lower court had struck down the even year election law. So the law, as a matter of law, was county legislators run for 2 years. So they go, you're a candidate. I want to run for office. I want to run for county legislator for a 2-year term. I get nominated. I carry my petitions. Those folks that relied on that signed those petitions, relied on what the law was at the time. And the law at the time was county legislators have a 2-year term. And then that process is come and gone. And now the state will have you believe that the triggering point is primary day or election day. You're probably hearing cases here. I'm sorry,
but wouldn't that require us to, if we were to make that leap, to that the candidates or prospective candidates had some kind of interest, property interest or other interest in the potential term? Because none of those terms have come into existence yet.
I would say this. I would say the signature on that petition by a voter is just as powerful as the person that walks into the booth or goes to vote on primary day or election.
So they have a vested interest at the time the petitions are passed in that prospective office.
And this court, they deal with it every day with election law cases, probably today. Is the petition, are the T's crossed? Are the I's dotted? Is there some defect with the petition process? Of course, that's significant.
I have a question for you, and I think this is accurate in the record. Every one of the counties, I know there's distinctions between the executive, every one of the counties has an elected legislature, correct?
That's
all 54 counties. There's no county that
I think constitutionally that's required.
Right.
I think,
but there's no county legislature that would be otherwise exempted from the effect of this law. Is it true that this law would affect every single county every single candidate for legislature?
Except I think county. I think Putnam's if my memory serves me right, that's the county that has 3-year terms for.
But they're all elected. They're all elected. If somebody.
That's correct.
Okay.
Your Honor. So I guess trying to stay in my lane of traffic, I would say if you agree with us on my last point, that it doesn't become effective for the 2025 election year, there's no need to rush this case along. The court deserves some time to consider it. This is a major, significant home rule constitutionality case. If there's no further questions from the court, I will rest on my brief.
Thank you, Mr. Carney.
Thank you.
We have Mr. Dolores next for Orange County.
Yes, thank you, Your Honor. May it please the court, William Madura on behalf of the Orange County plaintiffs. We agree that implicitly Article 1H or in Section Article 1H1 implicitly gives the right for us to set the terms of office.
A constitutional.
Correct. And that.
Actually, this is one issue that troubles me. If that's correct, why in Article 9, Section 2C, does it give the states, or it refers to here, some powers of local government here that can only be intruded upon by general law or special law? And the first one talks about terms of office. This is under Article 9(2). So why, if terms of office is in Section 1, constitutionalized, municipal home rule and all that, why do they put it in Section 2? It would seem to be redundant.
Well, Section 2 deals with the powers and duties of the legislature, correct?
Yeah, but then it says the
Subject to
powers
the Bill
of
of Rights.
the powers of certain powers of the local government. You know this probably better than I do, but my understanding of Article 9, Section 2C is talking about the state can intrude by general law or special law only, by general law or special law upon these areas of local government control of concern. One of them, the first one, is a laundry list of things, one of which is terms of office. So why would this legislature, if they can't intrude on that at all under Section 1, why mention it in Section 2?
Because it's Section 1 is more implicit. Again, as we went over before, you're not going to read in Section 1 that we have a specified right to set a term of office.
It's like a belt and suspenders. You already got it, but
so
you.
Then article, go ahead.
That seems kind of odd to include it in 2 if it's implicit in 1, but maybe I'm misreading that statute. How about this question? Do you think, could a county say, we're going to have our elections on a different day? There's a state election law, I think it's 1-800 or 800-1 that says the general election shall be held on the Tuesday following the first Monday in November, right? That's the state law.
Correct.
Right? If the county said, municipal home rule law, we control the terms of office, we control our officials, you know something, we're going to do, it's too crowded, then we want to do it in the first Tuesday of October, September, August. Could a county do that?
I don't believe that there's any statutory right for them to do that.
No, I'm saying if the counties want, in their charter, they put in a charter, we want our elections to be in August or September. We have a state law that says it has to be in November, first or second Tuesday. Could a county say, no, we don't like that. This is a matter of local concern. We want to set the timing of our own election. Different day.
Again, that's not, I wouldn't say that specifically set forth that they could do that. Yeah, I think these facts are much more closer to.
Prior to the current amendment, does the municipal home rule law give the counties the ability to move the date of the election around the calendar?
I'm not aware of that, no.
So the counties can't control the date. The state has a law in the election law, a general law that's valid. If the counties can't trump that with their charter, but they can trump it with the terms of office for their elected officials. And they do trump it with this even odd issue.
Again, that's.
Yeah, I know, these are unfair.
It's a hypothetical, you may be too far from me.
Yeah, no, I
think focusing on the facts of this case.
Counselor,
which is complicated enough.
Right.
Go ahead, I'm sorry.
No.
Here's where at least I'm at is if we were, the court below said there's a constitutional right to set the term of office. What does that mean? And where is it? Because if you have a constitutional right to set the term of office, then it can't be abridged by a general or special law.
Yeah.
And what we heard before, I think, is that constitutional right is a compilation of the Section 9, Article 9, Section 1, and the enabling legislation. We've got to piece it together. Is that your position?
Yes, and I think the court below, relying on NIDEC, did that very well. Again, they centered on municipal home law rule, section 333B, that provides title shall provide for the manner of election or appointment terms of office. In NIDEC, their subject was the appointment of terms of office. Here, our subject is the manner of election. And we choose our manner of election is odd number years. And again, it flows that is, then we can rely on Article 9, Section 2, that can only be changed by the state legislature, either by special law or general law. And again, it's gone over, I can go over it again. This is not either a general law or a special law.
Would you agree with this much? The Supreme Court on the general law issue, its analysis was much more limited than the county briefs that we're seeing. The Supreme Court just said NIDEC's already resolved whether this county law section 400 is a general law or not. And so that's the end of that because it went up to the Court of Appeals. That you're not relying on that, are you? I mean, it's not whether county law section 400, that dealt with 407. We're dealing with 408. It's not whether the general statute, the statute as a whole is a general law. It's whether this new law is a general law or not. NIDEC was, I don't know, 50 years before this law was even passed. So we just can't say, the trial judge said NIDEC, that's the end of it. We need something else there, right, to support a finding that it's not a general law, right? NIDEC had nothing to do with this law. This law wasn't even envisioned. Would you agree with me on that?
Yes and no, in that Municipal Home Law Rule 333B, which NIDEC relied on, was there.
Yeah, maybe the reasoning of NIDEC, because the court there struck down section 7 of 400, the same reasoning applies here to the new law, which is section 8. I get that.
Yes.
That's not what the trial court here did, but I get that there's maybe a way to rely on it as the reasoning there, I suppose, but not the result.
Well,
NIDEC had nothing to do with the EYEL because it wasn't even under consideration.
correct. And there's no case out there that has to deal with EYL, so we have to piece everything together and hopefully come to a rational.
Right, but I guess you're saying
conclusion.
they said it wasn't a general law because there were some counties it didn't apply to, and that rationale, there's some counties in your view this new law doesn't apply to.
Yeah.
Or, actually, the argument, I think you would concede it applies to every county. It just doesn't apply to every county official who runs for office, or every county official, because there's some who don't run for office, right?
Well, it doesn't apply to every county because not every county has an elected executive.
But
county
just so
executive.
by constitution, they have elected county legislators, and they have town officers, village.
Correct.
There's not a single county, 62 or 57, we're only concerned with 57, that does not have elections for county, village, or town, right? They all have elections.
That's my understanding.
So this law would apply to all those counties. It wouldn't apply to all the public officials in those counties because some don't run for office, right?
Which is how, like NIDEC said, is that NIDEC said it's not 407 was not a general law because it appeared to mandate certain elections and did not apply to counties which have an option of either elected or appointed official. So that's how come NIDEC said that there was a separation that also applies here.
I see. Okay. Any other points you want to advance here this morning?
No, I would just join in that in the event that the even year election law is put back, that again, it not apply this year's elections. Or my predecessors well-reasoned argument that this process already started. People are relying on when they sign petitions.
Sign the petition and might not have signed it if they knew it was 1 rather than 2 years.
Correct.
Isn't a corollary point there that maybe other people would have run for office or not run if they knew it was 1 year? right? You could get different candidates. If they had known from the beginning it was going to be two, assuming that's the way it goes. One. Maybe you'd have a different slate of candidates getting petitions, right? I mean, this is in support of your argument.
Yeah, but we have to, again, I think what's important is what we have now, and that people started this process with the understanding that the even year election law had been declared unconstitutional, and that, you know, the rules shouldn't change mid-game.
Well,
Is guess the best way to put it.
they certainly knew what was in play. I mean, there was the statute and then there was litigation on the statute. It's definitely something that they had to think about, that there's a possibility it's a 2-year term or a 1 year, depending on, the precise timing, really days, gets down to the day that the court changed, declared the law unconstitutional. I mean, are we really going to get into that timing?
That's our request, because again, the process has been started. People have relied on these terms when the process started. And again, it would be kind of changing the rules.
And
Which
my
team?
understanding is it's not just the candidates, it's the people that sign the petition.
Exactly.
So it's more expanded.
They were signing a petition for, say, in Orange County, a 2-year legislator position or a 4-year county executive position. So unless there's any further questions, I'll rest.
Thank you, Council.
Thank you.
Mr. Rhodes.
Good afternoon. It please the court. I will primarily rely on my brief and the arguments of my colleagues here. I believe that there are a few things that the state mentioned in its argument that I'd like to highlight in advance of getting to one additional point. To Justice Lindley's recent question about the fact that this applies to all counties, I think Putnam County is where we have to focus. And the state in its comments noted that the legislature felt it was necessary to make that carve out because mandating a term change would be an overstep.
Right.
But that is in
So
fact.
it doesn't apply to anyone running for county ledge in Putnam. It would apply to the county exec in Putnam? Would it not? Do they have an elected or appointed? Do you know?
I don't know.
Yeah,
that.
I don't either. But they have some elected town officers, I suppose, a town board, town supervisor, doesn't apply to town judges, village supervisor would, as long as there's one, it would seem that it would apply to the county. All county, again, not all county officials or local officials, but in any event, your point's well taken. There are a lot of carve-outs here. We have constitutional carve-outs, doesn't apply to the city of New York or any county in there. So you got 57 rather than 62. You got, doesn't apply even in 57 to the sheriff, the DA, county court, all those. Doesn't apply to city elections. So doesn't, in your view, that doesn't sound very general.
Correct. And I really wanted to highlight the state's comment that they believe that mandating a term change for Putnam County would be an overstep. And yet that's exactly what it's doing, is changing the terms of the officials who are about to run.
Oh, I thought they carved out the 3-year, no?
They carved out the 3-year, and the state in its argument said that the justification that the state had was that that to require Putnam County to go to an even number of year term would be an overstep by the legislature.
Well, 3 years is even 50% of the time.
Correct. But the idea that the legislature did not want to direct Putnam County to change the terms of its offices because that would be an overstep signals that it's an overstep to all of these officials who are now running, because they too will have their terms of office changed.
So, Counselor, if the state decided to carve out the 3-year term or not carve out the 3-year term, how does that implicate the state's constitutional authority or power under Article 9, Section 2 to amend the municipal home rule law? I mean, whether it's a good idea or not to carve out Putnam County, that's not for us to decide. I understand, everyone understands here that for prospective legislators who are running today for an office to begin January 1 of 2026, their office is going to be truncated. Right.
should the law stand.
No doubt about it. Your office is changing. The question is, does the state have the authority or is there some prohibition on the state for modifying that? You've got to establish a constitutional right to set the term of office.
I think that would go to the implicit right under section 1, but this point goes more to section 2, where this isn't a general law because it makes that carve out, and the legislature recognized that it had to make that carve out because it didn't have that it should not have the authority to change the terms of local office.
Yeah, I think once we get to these carve outs and whether it's a general law or special law, I think the fight seems to be on section 1. Once you get to section 2, based on Court of Appeals case law, there was that Hotel Dorset case. I don't know if you read that one. There was a law that applied to one cultural institution and one constitutional institution alone. And the Court of Appeals said that's general. The Court of Appeals has approved classifications as long as they're rational. The law review article, I don't know if you cited, but it was in a lot of the briefs from St. John's from 1985.
Mhm.
Did you cite that one?
I don't recall if I cited it, but I recall reviewing it.
It was called, I believe, the ghost of home rule, meaning, and that was 1985. It was dead then, okay? And to the extent that it was dead, the Court of Appeals kept shooting it over the years. Now it's really dead. So once you get there, almost anything goes now, it seems, with the Court of Appeals. I'm not saying whether that's right or wrong, but they are a higher court. So once you get there with all these, like, there was the firefighters case where the Court of Appeals said it was a state concern where the municipal employees lived for a residency. There was the district attorney's case where they said how much the district attorney makes is general. So once you get into that realm, it's a tough argument for you. Not impossible, but given the case law that we're bound by, the Court of Appeals lets a lot go.
Sure. I would, however, note that we did cite a couple of appellate division cases that have gone the other way. And the Hoerger, Hoerger, and Carey versus Oswego County Legislature did come out the other direction on whether those issues were of local concern. I believe you have gotten this, Justice Lindley, based upon the way you've phrased some of your questions. But my read of the Kelly case, and that's the Court of Appeals 1982, is that the court doesn't need to get to substantial state concern unless it determines that this statute is not one affecting matters of local government. And the court there said the legislature has the power to act in relation to the property affairs or government of any local government only by general law. And obviously there are the limited special law exceptions. And it goes on to say nothing in Article 9 is intended to impair the power of the legislature to act in relation to matters other than the property affairs or government of a local government. So when the court then goes on to the substantial state concern, it's determining whether or not that relates to matters of local government or other than local government. And I believe, I don't believe anybody's disputing that this goes to matters of local government. So I don't think the court ever gets.
At best, it's one of these overlap cases for the state, at best.
Correct.
At worst for the state, it's purely local.
Right. And I think that was the only point that I wanted to add because I didn't see that analysis and wanted to point that out to the court.
Thank you, Mr. Rowe.
Thank you.
Mr. Geneva?
Good afternoon, Your Honors. May it please the court. I will be very brief because I intend to adopt as my own the arguments of Mr. Carney. And also I will submit on the legislative equivalency argument, rely on my brief, given that counsel for the state did not argue. I would just like to reinforce a concept that I think Justice Lindley just spoke about. And I think, and it's in response, I think, to you, Justice Del Conte, as well, when we talk about whether something is implicit or not. As I thought about the underlying issue and I read 1H1, I said, where does this right reside? And I think we have to go back to the fundamentals associated with the municipal home rule law and the whole concept of why it is we have home rule. And home rule functions as both an affirmative in the affirmative in the sense that it places limitations on the legislature, but it also acts as providing affirmative grants of power. And those powers are really about self-determination by local entities. So I think it goes beyond implicit, because if home rule and the legislation, the municipal home rule law is designed to ensure and empower people to have self-government, the autonomy of exercising their rights in a local way, then to intrude on that in something as basic as a term of office or something as basic as when they hold elections is to intrude upon a fundamental right. And I think the legislature always understood that. I think the concept of home rule understands that. And even though it may have been chipped away over time, these are fundamentals. These are, how are we going to govern ourselves? How are we going to self-govern ourselves?
So
how are we going to choose elections?
The Article 9, Section 1 authorize alternative forms of government. An alternative form of government is defined in the municipal home rule law as the ability to have a charter county, to have your charter, right? It seems like the argument is because you have a constitutional right to have a charter, i.e. an alternate form of government, to structure the local government, anything you put in that charter becomes constitutionalized. Is that?
That's correct. And I think
no matter what, if it's not in the charter, if it's just a local law, it can be superseded by state law, right? But if you tuck it into the charter, it's protected.
I think the charter has meaning, and the analogy I'd use is almost like the Articles of Confederation back in the day, when states preserved to themselves certain rights and obligations and responsibilities. And here, the charter is our way locally to say, you are empowered to run your own affairs. And how you run your own affairs is your business.
Even if it's contrary to general state law.
Well, if it's contrary to general state, there are times when it can be inconsistent with general state law, and our cases have supported that. So all I'm suggesting to the court, and I'll end with this, is I think we have to go back in time and be informed in evaluating what this is and what exactly it is this legislation seeks to do.
Right. And you care to respond to the reply brief from Mr. Zarni, I think, and he said, responded to your charter argument. Rights that our county gives themselves in a charter have protection from being superseded by the state. They are, in effect, part of the Constitution. He argued that if that's correct, the counties have more authority than the state itself, because the state can amend any state legislation it wants. But the counties have more protection because the state can't supersede anything in a charter.
I think the counties have whatever powers the Constitution makes clear or vested or reserved to them. I wouldn't characterize it as the state having more power or less power. Those powers are defined. Our Constitution defines it, and defines it in a way that allows circumstances, as in Section 2, which we don't think applies here, to adopt general laws, special laws, or matters of substantial.
And put them in a charter, and therefore they can't. So if they put in a charter, we're going to have elections on a different day in a different month than the state prescribes. That would be.
It's a tough question to answer, okay? And I think the fact of the matter is it an absolute? I can't stand here and tell you it's an absolute. I can tell you under the facts of this case.
Because there's provision in Article 9, Section 2 talks about the counties have rights over salaries of the employee or the labor law conditions for contractors. Could they put in a state charter, labor law 240 sub 1 doesn't apply to our contract?
Well, I think what makes it a little bit different is we have the prefatory language, which talks about subject to the rights in this Constitution. And that brings us back to Section 1. And Section 1 speaks to the manner and form of government that we form.
Okay. All right. Well, we'll take a look at that. Thank you.
Thank you.
Mr. And I apologize in advance if I get this wrong. I know we've had you in court before. Tysland?
Thank you, Your Honor.
It doesn't sound correct based on your response. How do you say your first name? Last name?
Saitlin.
Saitlin. Okay, I
Yes.
apologize.
Mishit Saitlin. I represent the Ashlaw plaintiffs. A significant difference between who I represent and who my friends represent is, along with representing Suffolk County, I represent towns and individuals. So I'd like to focus my remarks primarily on the issues that are specific to the towns and individuals. But since I am representing Suffolk County, I did want to make one important point about the implementing legislation questions that have primarily come from Justice Del Conte. In the Harkenrider decision, which is where you've seen me before, Justice Lindley. The Court of Appeals held at 507/509 that implementing legislation that was adopted to come into effect when the constitutional amendment is adopted is constitutionalized. There it was the 2% rule that was adopted by legislation right before the people adopted the anti-gerrymandering amendments, and then they adopted them. And the Court of Appeals said that that was constitutionalized. In the same way here, the municipal home rule law, not all these other hypothetical things about 99, but the municipal home rule law, the 33 and 10 that were adopted right before the constitutional amendment and became effective upon the amendment's adoption are constitutionalized under the clear reasoning of Harkenrider. And it's an exact parallel, in fact, because you have a law that's clearly implemented by a subsequently acted constitutional amendment very close in time. I think that decision is directly on point of 507 through 509. And then the other thing on the 99-year hypothetical, I think, and we'll touch on this a little bit near the end of my remarks, that kind of county charter would violate a slew of individual right provisions under the Anderson-Burdick framework. So it would be struck down as violating the voters' individual constitutional rights and the various provisions that we cite. Now, turning to the town's arguments as they relate first to Article 9. Of course, those arguments, to the extent that they're grounded in Section 1, are not grounded in H1 because we don't have charter provisions. But we made the argument, and count 6 of our complaint says that the right to establish our terms of office is grounded in Article 9, 1A and 1B. There was absolutely no response from the state on this point in the trial court proceedings, not in their opening brief, not in their reply brief. In their opening brief in this court, they didn't respond to that count in our complaint. Finally, for the first time in this litigation, in the reply brief filed yesterday, it's the first time they say anything about it. And the only thing they do is they cite Radish. They don't talk about the constitutional text. They don't talk about our arguments that implicit in the concept of electing your own representatives, you got to be able to choose the term of office. Radish is a case where the legislature was acting under Article 13. There were no arguments, as far as I can tell, in that case about the powers that localities have under Section A and Section B of Article 9, Section 1. If an ordinary litigant came to this court and for the first time in a reply brief attempted to respond to a count that they claimed to deserve judgment on, I think I know what this court would do to that ordinary litigant.
Well, we would look at the merits of your argument and see if we agreed with it or not.
I think
because you have the burden right here, your challenge, the constitutionality. So let's say that that your clients have a right under some provision of the Constitution. The other side ignores it. We just wouldn't agree with you. We would say we would have to look at the merits of it, right?
Obviously, the court can do what it wants, but my understanding is if I'm representing a commercial client and I don't, or even I'm representing a county or a town, and the other side makes an argument, and I don't respond to that argument any which way in the trial court, in the opening brief, not to my reply brief. What happens if I ever did this, what I would expect is a decision from the court saying the points are conceded. You did not argue against it in the opening brief below, in the reply brief below, in the opening brief here. We accept the other side's argument. This is adversarial litigation.
Even if we think it has no merit, we accept it because it was not responded to.
That's the nature of forfeiture and waiver. I mean, this is not, and look, if we had a pro se opponent at the court might fill in the blanks, we have the state of New York represented by the Attorney General. The reason I think that we're trying to suss out what the interpretation is at oral argument for the first time is they sandbagged us. They didn't put it anywhere. This was our lead Article 9 claim. This wasn't like some tag-on claims. Our lead claim, our lead point in the lower court, our lead point here, and we didn't get a response.
Just to be clear, the court below didn't buy your lead point.
I think
Because the court below didn't say you have a constitutional right under section, Article 9, Section 1A.
I think it's fair to say that the court below was primarily focused on the county's arguments, which makes sense given the number of arguments that were put before it. But they
did. My point is that court didn't buy that argument below. It doesn't appear based on the decision. But your position now, just to be clear, is that within 1A, 9-1A,
Yes.
There's a fundamental right on the part of the local, of the county or the town, your
Yeah.
town clients, by virtue of being able to have a legislative body to be able to set the term of office.
Yes, that's our count 6. It was never responded to by the other side when they asked for judgment. Certainly they can't be entitled to judgment on a count that they didn't respond to.
Under 9(1)(a), could a town or local government set qualifications for office different from state law? Because you're talking about we can have terms that are different from a state law. Could you say, we're gonna say can't be, you have to have certain qualifications that are different from the state law. Could you do that too?
I think that would be a much harder question. And there I would loop back onto the first point that I was making, which is that in order to understand the contents of these broad phrases, you can look under Harkenrider to the implementing legislation adopted at the time. And we know terms of office was in there. The kinds of things that Your Honor is talking about there, that wasn't in there. So that would take a whole lot of extrapolation. But under Harkenrider, we can look at implementing legislation. And implementing legislation has not only Section 33 of the Municipal Home Law Rule Law that deals with counties, it also has sub 10 of Municipal Home Rule Law, which deals with towns.
Do you have any thoughts on why, if there's a constitutional right to terms of office under Article 9, Section 1(a) or B, or 1(h)(1), terms of office appears in Article 9, Section 2, where the state can intrude on those matters as long as it's by general or special law?
Yeah, I mean, as I read that provision, I think it was talking about essentially what's in implementing legislation, because they were kind of paired together. And since implementing legislation had provisions for terms of office, it's kind of mirrored in that provision of Section 2. I mean, it's the whole thing, the whole package, both the implementing legislation, the home municipal home rule law, and the entirety of the home rule provision were essentially considered by legislature and the people together.
We should ignore Section 2 says the state by general law can pass laws that affect the local concern with respect to terms of office. That's unenforceable under your view, right?
I don't think that that's what provision says. What the provision before it says what the legislature can pass. It says subject to Section 1, it can pass certain legislation. But I would like the opportunity, though, a little bit to address the point that Your Honor was making about special laws in the context of towns in particular, because it's very important. While we have this challenge with Putnam County, which we're going back and forth, the issue on towns with regard to whether the even year election law was a special law is, I would respectfully submit, really easy. There's a specific carve out in the even year election law that says if your town is conterminous to the village, you can keep having odd year elections for all of your offices. So it is clear that it is a special law, and that's the first section of the even year election law. We raised this point in our brief, no response to the reply brief. So it is very clear that it is a special law, at least with regard to the towns, because at least 5 towns, as far as we were able to determine, or maybe more, are carved out entirely out of the even year election law. So then we would move on into whether turnout in local races and town races is an issue of statewide concern. And I think that the Baldwin case from the Court of Appeals essentially answers that question, because Baldwin says that where you draw ward lines is purely a local issue. If the contents of your wards are a purely local issue, then who turns out for them must be as well. It would make no sense to have a doctrine that says that, the state has no interest in where you draw the specific ward lines, but it has an overriding interest or an important interest in
this. But don't town and village elections have a dramatically lower voter turnout than the state and federal elections?
It is true that more people.
And to advance the state argument, and I don't want to put words in the council's mouth, but I believe her argument was to sync those elections, it will give voters a greater participation because they're coming to the polls anyway, and placing those town and village judges on those even years give voters a greater participation in local races.
Yes, and my point for this, and I would like to address that claim, which we believe is an empirical claim which needs to be tested under the Anderson verdict framework. For purposes of this, my point is that if Baldwin from the Court of Appeals holds that where the wards are drawn is only a local concern, then who turns out for those same wards is also of local concern only for the exact same reason. But I would like to turn to the Anderson verdict claims. These are individual rights claims that we raised on behalf of our individual voters. And my friends conceded that this is analyzed under the Anderson verdict framework. And that is an intensely fact-specific framework. We alleged that lumping these elections together would cause voter confusion, would cause longer lines, would cause ballot drop-off and fatigue. We also alleged that any claim that there would be more voting in the local elections was illusory because of the ballot drop-off issue. And what the ballot drop-off issue is, I come because I want to vote for president or senator or governor. I come and I keep going through my ballot. I get to the town council. I'm just not going to bother that. That's not why I showed up. And we made an allegation in our complaint, a well-pleaded allegation, that any benefits that the state's going to have to justify these real burdens that we pleaded is illusory. That's a factual issue.
Did you compare it to the voter drop-off in odd years?
What we said in our complaint is it's the notice pleading is that the benefit is illusory. If we lose on Article 9 and the court sends the case back on the Anderson verdict, we have an expert that we are going to proffer that will say that the turnout benefits in local elections are expected to be either zero or a little more than zero, essentially meaningless.
I was under the impression, but I think I might be wrong, that all parties, plaintiffs and defendants, all of them agreed that this was ripe for summary judgment as a matter of law, and nobody needed a trial or discovery. And was that not your client wasn't on board with that?
No, I want to be very clear about this. The way that this happened is we had our Article 9 claims that we agreed with everyone should go to summary judgment decisions.
Right. Up or down?
Up or down. We said to the Supreme Court, we said, we've got our individual rights claims. Let us have discovery. Let us develop these claims together. What the court said is we're gonna decide the motion to dismiss on the individual right claims in parallel with the summary judgment issues. So they filed a motion to dismiss only on our individual rights claims. We never asked for judgment. All we said we want is we want to be able to present our experts. I've got draft expert reports that are ready to go. Anderson verdict is not a rare doctrine. These claims are litigated usually in federal courts over the country. They are almost never dismissed at the motion to dismiss stage outside of very odd circumstances.
Well, didn't Judge Neer agree with you on the voter drop-off? And he didn't get to the Anderson verdict though, right?
He denied the motion to dismiss, but of course, having gotten judgment, a final judgment on our Article 9 claims, there was no reason to continue to litigate our individual rights.
Anderson verdict isn't necessarily contingent solely on voter drop-off, but the delay, increased lines, and maybe people won't participate if there's so many other people voting.
Yeah,
right?
That's right, Your Honor. And these are the typical kinds of allegations that I'm not going to gainsay. Always survive motion to dismiss. We gave a couple examples of federal district court cases, places states had abolished party line voting. People said that's created longer lines. Survive motion to dismiss. In New York, we had not giving inactive voter lists to local clerks. I mean, I even won that case.
Usually on the other side of this, I would take a wild guess.
I've usually been on the other side of that, and I've never won a motion to dismiss. and it would be quite the first. And I would like to say something about the Coral case that they raised for the first time in their reply brief. As this court would notice when it looks at that case, that was an election law case under 16 that requires a verified petition and all your proofs with it. So this court was deciding that case on a factual record. Here we have a complaint. We have they in their brief in this court cited a couple of social science articles. Yeah, bring in those experts in the trial court. Or bring in someone else. We'll bring in our experts. We'll depose them. Litigating those cases on the other side. I always have to bring in my experts. I've always had to do
So-
theirs. Now,
Counselor, if
Yes.
I just want to make sure I may have missed something procedurally here, but so we have a declaratory judgment action as it relates to the statute. And then we have these separate claims that relate to the what you call the factual, the nuances here. Are
Yes.
you asking for severance?
Well, request is for affirmance, then our claims would be,
I know, I understand that, but essentially, you're saying that you stipulated below to the court dealing with at least part of the allegations of your complaint vis-a-vis summary judgment. And
yeah,
then leaving behind the other allegations?
yeah, so there was they filed a combined brief.
No, I understand that, but
Yeah.
you're essentially saying severing these claims would be perfectly fine with you.
Yeah, and in fact, that's what we asked for below. That's one of the reasons we resisted transfer to Onondaga County. We didn't want to come to Onondaga County for exactly this reason. We told the court,
In particular, your fact, assuming you were to develop your facts, they would be unique to your locality.
well, we have a lot of different clients. We have clients all over the place, but yeah,
There might be facts that are unique to your locality.
to the localities, we have clients in a bunch of counties, both individuals and towns. And just to be clear, Your Honor, we resisted consolidation. We did not want to be consolidated for this very reason. We told Supreme Court on Onondaga County, our individual claims are fact specific. We need to proceed with discovery. We need to proceed with expert reports. Leave us alone in Jefferson County so we can do that. We were assured.
Can you do that, let's say the court were to affirm on the other issues. You could still pursue those claims, could you not?
We would, and just end it with candor to the court, if the court rejects our argument that it doesn't apply to 2025, we have the right to pursue those claims. I've got expert reports ready to go to file emergency injunctions saying, hey, we've got these individual rights claims that cannot be dismissed since the passage of time has occurred. You got to have the injunction for 2025. Now, if the court hypothetically rules against us on the Article 9 claims, but makes clear that it doesn't apply to 2025 for the voter and candidate reliance issues before, then we'll litigate them after issuance of remitter, assuming the Court of Appeals doesn't overturn the Article 9 issue in an ordinary course. We're ready to go with our experts. I'm sure the state can retain its own experts. Maybe they'll call up the authors of those articles they cited respectfully and properly in their opening brief here, and then we can have the usual, I'll be on the other side of the Anderson verdict for once, but we'll have the usual.
Your concern here is a judgment or something that would otherwise be res judicata or collateral estoppel as it relates to those claims.
Well, I'm concerned about an order ordering those claims dismissed, right? They asked in their appeal to reverse the denial of the dismissal. Obviously, if this court affirms the dismissal, I got nothing left to do. But if the court agrees with me, the Anderson verdict is fact specific, not subject to dismissal, then the court should so say and then issue remitter. And I would ask in that circumstance to have remitter issued post haste so we can proceed very quickly in Onondaga County if the circumstance that the court says the even year law applies to 2025. If the court makes clear that it doesn't, then obviously take you all the time to issue the remitter. But we'll need to act quickly in that circumstance on those claims which we never had a fair opportunity to litigate. And it's the reason we resisted consolidation. We were worried about this exact situation. We get caught up in all the Article 9 claims and our very substantial individual rights claims get lost in the shuffle.
All right. Thank you, counsel.
Thank you.
Ms. Fiden, you are last on the list. And you may proceed.
No,
We
can't.
still can't hear you. You can hear us though, I assume? Well,
Judge, I did send her instructions on dialing in with the phone.
okay, all right, that's a first. I will say,
Loud and clear.
I'll say this, we understand that there's a date in Albany at the Court of Appeals a week from today. And so we're aware of that with respect to getting the decision out. In that same line, there's no rebuttal, as you know, here, but we do accept post-argument submissions. I would encourage you to get any post-argument submissions in post haste, to borrow a word from counsel, by the end of the day, if possible, and then we will hopefully have a decision with you for you shortly thereafter. Thank you all very much.